Your Lordship, on submission, Your Lordship, in serial number 18, 130, I made a mention. The petitioner advocate is present, Your Lordship. Serial number 18, Your Lordship. Your Lordship,
Business.
Your Lordship, on submission, Your Lordship. Serial number 18, Your Lordship. Morning, it has been 12, Your Lordship. The petitioner informant, petitioner advocate is present or either.
What's the radio? He wants it on 18.4. 18.4. Yes, next.
I owe apology for causing inconvenience.
27, we not ready for the petition now. 27.
I'm for respondents 1 and 10, my lord.
Yes. Yeah. So that is the only probably appear to be just. Finding that it is a res judicata, say, may not hold it. But on the merit to oppose the application, you will have all the opportunity. At that point, there is no discussion at all in the impugned order. You can oppose the application on the other grounds, say whether the appointment of commissioner is warranted. You can demonstrate to the court that it is not warranted or it amounts to collection of evidence. So that aspect in this matter, say in this petition, I am not going to observe anything. On merit, I don't touch.
May I make 2 submissions, my lord?
Please.
The last page of the impugned order, my lord, page 14.
Yes.
Page 103, ink page 103.
Yes.
The last 2 sentences.
Yes. That is only a passing remark.
Yes, my lord. And the other point I would like.
Ganapati Shloka he has stated. That is all.
Yes, my lord. Another point is This
Yes.
is a suit of the year 1994, my lord.
That
It
will
has-
say fix the time framework.
Yes, my lord. Much of it. Because it has already come before the Honorable High Court in RSA. It was remanded to the First Appellate Court, and First Appellate Court again has remanded it to the trial court, my lord. Again,
Yes.
court has passed a judgment, and now it is before the Appellate Court.
Yes.
Factually, everything is admitted, my lord. The sale deeds between the plaintiff, defendants, everything is admitted by both sides.
The present petitioner. Yes, please. Page 83. 83 in the original memorandum of petition. Yes.
Denote the measurement and boundaries. That is the collection of your.
ಅಲ್ಲ ವಕೀಲ್ರಿ, ಬೆಳಗಿಂದ 28 ಸರ್ತಿ ಹೇಳಿದ್ದೇನೆ, 29ನೇ ಸರ್ತಿನೂ ಅದನ್ನೇ ನಾನು ಹೇಳಬೇಕೆ. ಅದ್ರ ಬಗ್ಗೆ ಏನೂ ಹೇಳಲ್ಲ ಇತ್ತು. ಅದು ನಿಮಗೆ ಓಪನ್ ಇಟ್ಟಿರ್ತೇನೆ. ಆ ಪಾಯಿಂಟ್ ಹೇಳ್ತೇನೆ. ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಬರೀ ಸಿಂಪಲ್ ಪಾಯಿಂಟ್, ಟೆಕ್ನಿಕ್ಯಾಲಿಟಿ ಬಗ್ಗೆ ಮಾತ್ರ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೇನೆ. ಉಳಿದಿದ್ ಮೆರಿಟ್ ಮೇಲೆ ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಏನೂ ಹೇಳಲಿಲ್ಲ. ಅದನ್ನ ನಾನು ಟಚ್ ಮಾಡಲ್ಲ. R1 R10 ಹೇಳಿದ್ರು ಒಂದು ಸೆಂಟೆನ್ಸ್ ಇದೆ ನೋಡಿ ಅಂತ ಲಾಸ್ಟ್ ಪೇಜ್ ನಲ್ಲಿ, ಪೇಜ್ 103. ಅದು ಹೊರತಾಗಿ ಬೇರೆ ಏನೂ ಹೇಳಲಿಲ್ಲ ಅವರು. The present in the suit filed by the present petitioner as plaintiff in OS number 150/1994 in the court of so and so. For the relief of permanent injunction, declaration of title and mandatory injunction. The present respondent number 1 as defendant number 1 had filed an application for Order 6 Rule 9 CPC seeking the appointment of Commissioner for Local Investigation. Said IA it was numbered as IA number 10 came to be dismissed by the trial court under its order dated 16/2/2000. Thereafter, the suit of the plaintiff also came to be dismissed on merit. It was dismissed as divide of merit. Challenging the same, the plaintiff filed an appeal in RA number 103/2015, of so and so, the first appellate court. During the pendency of the said regularity, the appellant, who was the plaintiff in the trial court, himself filed the application IA number 5 and Order 26/9 CPC taking the appointment of commission. After contest, the said application by the order of the First Appellate Court dated 27/3/2017 came to be dismissed on the ground of res judicata. Agreed by the same, the original plaintiff was the appellant in the regular appeal, has filed this writ petition. Also for the petitioner in his argument, submitted that when in fact the first application filed by the defendant number 1 in the original suit, though was under 26 rule 9 CPC, but it was too vague with various prayer in it. As such, the trial court rejected this said application. However, the change of circumstances since conducting a local investigation for denoting the measurements and boundaries of the social property was very much necessitated. The plaintiff was constrained to file a similar application. However, the trial court, without appreciating the same, has erroneously rejected this application. For contrast, the counsels for the respondents in their argument submitted that since the very plaintiff who had earlier opposed the similar application filed by defendant number 1 cannot maintain the second such application, pray to dismiss the writ petition. It's not in dispute that during the pendency of the original suit, the defendant number 1 with the respondent number 1 herein had filed I number 10 and order 26 rule 9 reduced section 151 of CPC seeking appointment of a court commission. As could be seen from the certified copy of the said application placed before this court today, the purpose for the appointment of court commissioner was shown to be for singular from a local investigation pertaining to the suit schedule property. What that local investigation mean and what the applicant is desirous of getting through the commissioner was neither explained in the application nor in the affidavit in clear terms. Even in affidavit also, they have stated that application was for appointment of the court commissioner for local investigation with the neat sketch and mahajar. Even in the affidavit also, he has not stated as to what the commissioner is expected to do in the course of his local investigation. This lacuna, this ambiguity, this vagueness in his application was the main ground for attack for the plaintiff who opposed the said application. Considering the objection raised by the plaintiff that the application was too vague, the trial court in its order dated 16/2/2000 dismissed the said IA number 10 filed by the defendant number 1. However, simultaneously, it also made an observation that since the suit was filed by the plaintiff, it was for the burden is upon the plaintiff to prove the alleged factum of possession of the social property. However, the said original suit came to be dismissed on its merit, and the plaintiff has preferred a regular appeal, RA number 103 of 2015. In the said RA, it is a plaintiff who has filed a similar application under 26 Rule 9 CPC, read with, or 26 Rule 9, read with section 121 CPC. It was numbered as IA number 5 for the very same purpose of appointing a court commission. The said application was opposed by the respondents on the contention that the application was hit by the principle of res judicata. The trial court in the impugned order, by relying upon a judgment of a coordinate bench of this court in G, Amama versus Gauramma, reported in 2002, 4 KCCR SN 362, was pleased to hold that the principle of res judicata is applicable even for interlocutory application also. And further, after a detailed analysis, dismissed the application of the plaintiff, holding that it is fit with the principle of res judicata. Except that the only other observation made by the first appellate court was that the additional grounds to receive additional evidence in the appellate stage by appointing a commissioner are not specifically pleaded. The above reasoning of the first appellate court that the application is hit by the principle of res judicata has to be considered very carefully. Admittedly, the matter has not been adjudicated between the parties, though in the original suit and in the regular appeal, parties were the same and the subject matter was also same. The appointment of commissioner that was sought for was for the purpose of local investigation as stated in the first application, which was numbered as IA number 10 in the trial court. However, except that nothing was mentioned as to what the local investigation the commissioner was expected to or required to do. On the other hand, in the second application of the plaintiff in the regular appeal in the form of IA number 5, the applicant has come up with a specific reasoning as to for what purpose the commissioner is required to be appointed. It's not the case of have you taken any specific plea anywhere, or is it your contention that in any proceeding commissioner can be appointed only once? Probably that is not your contention. It's also not the contention of the respondents herein that appointment of a successive commissioner or commissioner for more than one occasion is prohibited expressly by the law. In Arjun Singh versus Mohindra Kumar and others, reported in AIR 1964, Supreme Court 993, wherein also the question of the principle of res judicata was involved. The Honorable Apex Court was pleased to observe that scope of the principle of res judicata is not confined to what is contained in section 11, but is of more general application. Res judicata could be as much applicable to different stages of the same suit as to findings on issues in different suits. The court which rendered the first decision was competent to entertain the suit or other proceedings, and had therefore competency to decide the issue or matter The circumstance that it is a tribunal of exclusive jurisdiction or one from whose decision no appeal lay would not by themselves negative the finding of the issue by it being res judicata in later proceedings. It was further observed by the Honorable Apex Court that in the same judgment that where the principles of res judicata is invoked in the case of the different stages of the proceedings in the same suit, the nature of the proceedings, the scope of the inquiry, which the adjectival law provides for the decision being reached, as well as the specific provisions made on matters touching such decisions are some of the material and relevant factors to be considered before principle is held applicable. Thus, in the instant case, as already observed above, even though the second application filed in the proceeding, though in the appeal, was under the same provision of law, that is Order 26 Rule 9 CPC, for the same purpose of appointing of the commissioner. But as analyzed above, the previous application filed in the matter at the stage of original suit as IA number 10 was rejected on the ground that the application was too vague, and also that the plaintiff had various other avenues to discharge his burden of proving, for which the appointment of commissioner was not required. As such, the actual contention of the applicant therein as to what the local investigation he intended to be undertaken by the commissioner and was there any necessity for the same was not considered or reasoned by the trial court. Whereas the second application, though the applicant has stated for what purpose the applicant intends to have the appointment of court commissioner, at the same time, he also has made it very clear in the second instance.
As in the second application, though the applicant has stated for what purpose the applicant intends to have the appointment of commissioner. The same.
However, the first appellate court, without considering all those aspects, simply applying the principle of res judicata by going through the provision that a similar application to Order 26 Rule 9 CPC was considered and dismissed earlier, proceeded to reject the application on the ground on the principle of res judicata. Since the disposal of the first application by the trial court through IA number 10 cannot be considered absolutely on its merit, but more on the vagueness of the application. It cannot be held that the question involved being the same has already been adjudicated between the parties previously. Thus, the reasoning of the first appellate court in rejecting IA number 5 filed in RA 103/2015 that principle of res judicata applies in the instant case is an erroneous finding. Since IA number 5 has came to be dismissed solely on the ground of a single point of alleged res judicata, and which finding now proved to be an erroneous finding, the said finding deserves to be set aside. And since the first appellate court has not considered the said application on its merit, the matter requests to be remanded for considering IA number 5 fresh by the first appellate court. In the said process, the first appellate court shall not take into consideration its previous passing observation that the passing observation made by it in para 18 of its order that the additional grounds to receive additional evidence in the appellate stage by appointing commissioner are not specifically pleaded would not come in the way. However, the first appellate court would be at liberty to consider all other aspects touching the merit of the IA number 5 under consideration. Ordering accordingly, the petition stands partly allowed and the impugned. Order dated 27/3/2017, passed on IA number 5 in RA number 103/2015 by the Court of the stands quashed and set again stands restored on the file of the first appellate court for its fresh disposal in accordance with law. After hearing arguments of both sides on the said application of fresh. Next slide. Since the original suit from which the regular appeal has arisen is of the year 1994 and the appeal itself is of the year 2015, the early disposal of the matter by the first appellate court is highly appreciated.
Petitioner. Twenty-eight.
One minute, please. Yes, please.
For the permanent event, explain the respondents from not to application A number 2. Application and granted the consideration. Application. What is that? As a time of this equation balance of and that opponents have built a system of 2060 in the control. Big four. So looking to the prima facie and balance of convenience, according to the merits of the case, rejected the A. So it was the trial court order and rejected the A. Challenging here. Matter of OS number 16 of 2001. Right by one Chikkana, brother of the petitioner.
No, to show your alleged prima facie possession of the property and prima facie to show that say that was your exclusive property, what materials the trial court consider?
Certificates and article section moving records. Also produced in trial court. So you told that the scheduled properties.
Sir, ನೀವು ಹೇಳಿದ ಸುಲಭದಲ್ಲಿ ನಾನು ಬರೀಲಿಕ್ಕಾಗಲ್ವೇ? ನೀವು ನನಗೆ ಇಲ್ಲಿ ತೋರಿಸ್ಬೇಕಲ್ವೇ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇಸ್ ಸಸ್ಟೈನಬಲ್ ಅಂತ ಹೇಳಿದ್ರೆ ನೀವು ಅದನ್ನ ಹೇಗೆ ಒಂದು ರೀಸನಿಂಗ್ ಅಲ್ಲಿ ತೋರಿಸ್ಬೇಕು ಅಥವಾ ಅನೆಕ್ಷರ್ ಅಲ್ಲಿ ತೋರಿಸ್ಬೇಕು? ಇಟ್ I produced all sale deeds and it's verified all sale deeds and it's only then it has held ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ಅಷ್ಟು ಸುಲಭದಲ್ಲಿ ಬರೀಲಿಕ್ಕಾಗತ್ತೆಯೇ? ಅಷ್ಟೇ ಸುಲಭದಲ್ಲಿ ನಾನು it has did not notice and appreciate the discrepancies in the sale deed or say the principle of law and simply granted the temporary injunction ಅಂತನೂ ನಾನು ಅಷ್ಟೇ ಸುಲಭದಲ್ಲಿ ಬರೀಬಹುದಲ್ವೇ? ತೋರಿಸಿ, show me the reason why DI was granted to you, why that finding was disturbed.
Number 28. The plaintiff has made a prima facie case for grant of temporary intention as read in A number 1. Whether the balance of convenience lies in favor of the plaintiff. Whether the invitation is refused as read in A number 1, plaintiff is put into great hardship and must not be compensated in terms of other issues of orders.
Yes, please.
He also again filed against his older OS 16/2001.
No, that OS was for whom? Who has filed for what? Against whom?
OS 16/2005 Chicken, brother of this petitioner for the partition of separate possession. That suit was partly excluding this property of the Chicken property, partition granted in other properties. So the trial court hold that is the self-factor properties of this petitioner in the said OS 16/2001. By finding a possession for the suitable properties. The finding of the trial court admitted in OS 16/2001 also.
Yes.
Also, traditional certificates and also RTC extract and other revenue documents present. Report finding is that.
Vakilre, you come up with the copies of the original suit and alleged RTC and other things based upon which the trial court has given its finding. Trial court in order ಎಷ್ಟು ವೇಗ ಆಗಿದೆಯೋ ನೀವು ಅಷ್ಟೇ ಅದನ್ನ ವೇಗಾಗಿ ಹೇಳಲಿಕ್ಕಾಗಲ್ಲ. Based upon the sale deeds and based upon the RTCs, the trial court has granted the interim order. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಷ್ಟೇ ಹೇಳಿದೆ, ಬರೀ ಒಂದೇ ಪ್ಯಾರಾದಲ್ಲಿ ಎರಡೇ ಲೈನ್ ನಲ್ಲಿ. The plaintiff has produced this certified copy of the judgment in OS 16/2001 and has produced 6 sale deeds of so and so dates and the RTCs that prima facie go to show that he is in possession. ಅಷ್ಟೇ ಹೇಳ್ತಿದೆ, ನೀವು ಅಷ್ಟನ್ನೇ ಹೇಳ್ತಿದ್ದೀರಿ. ಅದು ಹೌದು ರೀ, ಆ ಸೇಲ್ ಡೀಡ್ಗಳು ನಿಮ್ಮ ಹೆಸರಿನಲ್ಲಿಯೇ ಇದೆ, RTC ನಿಮ್ಮ ಹೆಸರಿನಲ್ಲಿಯೇ ಇದೆ ಅನ್ನೋದು ನಾವು ನೋಡ್ಬೇಕಲ್ವೇ? ಯಾಕಂದ್ರೆ ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ವ್ಯೂನ ಡಿಫರ್ ಮಾಡಿದೆ, ನಿಮ್ಗೆ ಕೊಟ್ಟಿರೋ ಇಂಜಂಕ್ಷನ್ ಅದು ವೆಕೇಟ್ ಮಾಡಿದೆ. ಒಂದು ಸೈಡ್ ಮಾತ್ರ ಹೇಳಿದೆ ಇದು. Okay, do you consider that all the 6 sale deeds produced by instance in its name with respect to the social property? If you consider, it's fine. Otherwise, you have to produce. ಏನು ಅದಕ್ಕೆ ಬಿಟ್ಟು ಬೇರೆದೇನು ಎಕ್ಸೆಸ್ ಡೀಟೇಲೇ ಇಲ್ಲ. ಇಂಪ್ಯೂನ್ ಆರ್ಡರ್ ನಲ್ಲಿ ಏನೂ ಹೇಳಿಲ್ಲ. Counsel from both sides present. So in the submission of the learned counsel for the petitioner, it is observed that the learned counsel for the petitioner is repeatedly telling that the original suit 16/2001 was decided in his favor. Original suit was 16/2001 filed against the plaintiff came to be dismissed as devoid of merit and that partly alone. So came to be partly allowed, but it excluded the social properties. from the ambit of partition. And the trial court was justified in holding that the plaintiff has produced several sale deeds standing in his name. Admittedly, none of those documents are before this court, nor even the details about what those alleged sale deeds mentions about, or in whose name they stand, and with respect to what property. Though there is reference to about sale deeds and RTC extracts and also assessment register extracts, the learned counsel for the respondent submits that is not admitting any of them as that they are standing in the name of the plaintiff. In such a circumstance, since neither the impugned order gives any details and throws more light in that regard, nor the learned counsel for the petitioner is able to do it, matter could not be proceeded to. List the matter in the next week. Yes, ಅದು ಆಮೇಲೆ ಬರ್ತದೆ. ಈಗ ಅವ್ರಿಗೆ ಬೇಕಾದ್ರೆ ಫಸ್ಟ್ ಟೆಂಪರರಿ ಇಂಜಂಕ್ಷನ್, ಅದನ್ನ ನಾವು ಸ್ಟ್ರೈಟ್ ಅವೇ you work it out in RE ಅಂತ ಹೇಳಲಿಕ್ಕೆ ಬರೋಲ್ಲ. 2 weeks. Yes.
29.
Extended. For the respondent, who's respondent?
Appearing for the respondent, my lord.
Trustee.
Santosh Raj Deshmukh, my lord.
ಕೇಸ್ ಕರೆದಾಗ ಪ್ರೆಸೆಂಟ್ ಇದ್ದೇವೆ ಅಂತ ಹೇಳ್ಬೇಕಲ್ವೇನ್ರಿ?
My lord, ಅದು ಸ್ವಲ್ಪ ಮಿಸ್ಟೇಕ್ ಆಯ್ತು. I apologize your honor. ಕೇಸ್ ನಂಬರ್ ಮಿಸ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡೆ.
Yes, please.
Before filing of the written statement, the respondent being defended
For filing of the written statement.
The filed application for conviction given page number 55, seeking directions to the plaintiff petitioner to produce certain documents.
1 minute. Page number
55.
Yes.
The contention of the respondents seeking directions to the plaintiff to produce these documents. The plaintiff has stated in the client that for filing of the suit, the respondents have issued a notice seeking for the special temporary meeting. Along with the notice issued by the defendant, they have also issued some letter and signatures of this and that.
One moment. Yes.
Yes, on page number 29, the respondents have issued letter to the plaintiff requesting to talk of the special general body meeting, and along with the letter, they have also enclosed some annexes stating that some almost all the members they have signed on for calling for the special general body meeting. But the contention of the plaintiff is that even before issuance of this notice itself, there was already a stay injunction order in wise number 460 of 2016, restraining the respondent authority, Industry Association, from conducting the election. But question of calling for the special general body meeting to discuss the agenda of election issue does not arise. That is the regular from our side. But in the plaintiff stated that these signatures found at 31 to 51 are almost both and non-eligible members have also signed. This is the contention. What is the appoint application? When the report was, when we have scrutinized, when we have verified, when who has given report that these signatures are for, and which is the provision of the bylaw of the Industry Association restraining the respondents from calling for the special general body meeting and almost and even they were for the some provisions of law. For the objections filed by the plaintiff to the application filed by the respondents is these documents are for by the defendants are not in the custody of the okay. The same are in the custody of one who is the then general secretary, who is dependent in another source. And we have also given several letters. He has not handed over the documents. And furthermore, we have also enlarged that he was the then general secretary. In spite of that, he has not handed over the documents. And it is our statement these documents are for by the plaintiff. And moreover, to the suit and even not passing up by the honorable report by allowing the number 1, they are illegally conducting election and even now it is the defendants who are the custodians of the entire office. They are illegally active. But the honorable report without.
Can in such a situation say whether your suit still survives?
In that regard, they have also filed memo for dismissal of the suit. But that is posted or hearing on the. But in case
When you are the plaintiff, right? Yes. Being the plaintiff, when you say that your prayer was to hold that the proposed general body meeting was illegal and void, and according to that meeting has already been held.
that meeting was not held. The intention, idea number 1 was about that meeting scheduled to be held as per the prayers are not held. But subsequent passing of the matter, they illegally held another meeting and they are
Fine. So that meeting not held, the date has been lapsed. By effluence of time, your suit itself has become infructuous. Then how can you maintain this writ petition?
Yes, if the matter is going to be evidence.
You cannot anticipate that, sir. If this court makes any observation to the effect that your petition probably would not survive, you lose everything here and there.
I inform permission to 113. Order operated. The application filed by the defendant is hereby disposed of subject to following terms. The plaintiff is there to produce the documents sought by the defendant within 7 days within 7 days for inspection of the defendant or his counsel. If the plaintiff fails to provide such documents for inspection, he shall not be allowed to produce to any such document during the course of the evidence. At least to do that extent. In case if the trial court be not for evidence. Okay.
Right, on the learned counsel for the petitioner is present. Physically. Being agreed by an interlocutory order passed by the trial court directing him to produce certain documents of the details sought for by the defendants therein through their IA filed under Order 11, Rule 14, 15, and 16, the plaintiff has preferred this petition. The relief sought for in the plaint in OS 159 of 2017 is a short copy of which is produced at Annexure A, shows that it is a suit for declaration, seeking a declaration that the special general body meeting called by the defendants is scheduled to be conducted on 28/4/2017 at 12 noon at the Ridge Clubhouse, Royal Gardenia Layout, Bommasandra Industrial Area, Bengaluru. Is unjust, illegal, arbitrary, and contrary to the rules and regulations of the association. Even according to the learned counsel for the petitioner, the said meeting did not end on 28/4/2017. Further, by efflux of time also, the prayer sought for in the plaint has become stale. In such a situation, when the original suit itself appears to have become infructuous, both by its purpose and by efflux of time. It is not known how the present petition can be continued by the petitioner. Petitioner to convince the court in that regard before proceeding further. Is the matter in the next week. I have put it in writing. You have to convince me. Otherwise, the court may proceed to pass appropriate order, may be making some serious observations. Yes.
My lord, one submission, my lord.
Yes.
2 weeks, my lord. 3rd week, my lord.
Next.
One, Kiran J. One. Kiran J. for the petitioner. Country for two.
Yes, please. It is for a passover. Shall I grant the passover or shall I proceed with the matter? The junior counsel for the petitioner and the counsel for respondent number 2 are physically present. Though the current junior counsel for the petitioner prays for a passover of this matter, however, since the court time will be over in few minutes, the passing over of the matter would not serve any purpose. Let's list the matter on 18. 4.
Puneet K. 32 Puneet K for the petitioner. For R1 to
A direction was given to the respondent on the previous occasion.
Yes, I've seen it. The submissions to me to the questions of law and
Yes. You are ready. The microphone is on.
The aspect of territorial jurisdiction came to be transferred from the Court of Junior Division to the Senior Division. Now, my lord, since the application was filed initially before the Junior Division, and since that has the order of rejection of my injunction application was challenged by the district judge, thereafter now, my lords, because there is a change in jurisdiction, in the proper jurisdiction, this would be a de novo consideration of the threshold. Therefore, my lords, my petition would become infectious and will be given liberty, my lords, to file any application if need be for the appropriate court.
none of us can, the bar can come in the way of preparing any application before the court where he has represented the suit. The lordship wanted to know last time as to why the respondent says that the suit has become infectious.
Himself concedes that its repetition has become infectious. Therefore, the hearing on that point would be not necessary now.
Clarification I want to make to some of the court is, and the court which did not have jurisdiction, returned the plaintiff, and if he has represented the suit before the appropriate court, he ought to have made an application there instead of pursuing the requisition before the Supreme Court. The court, after returning the claim, becomes under submission. So it lacks jurisdiction to do anything. This honorable court is seized of the requisition, which is preferred against the order of rejection of the injunction, which is confirmed by the first appellate court. This court, my lord, the British proceeding before the honorable court is not a transfer of the suit, so as to say that it shall continue from the state where it was transferred. It is a simple case of return of the patent order, 7 reclaim. Court has nothing more to do that. Court has only to return the claim. It's for him to represent. If he wants to represent it with another application, or he wants to file a fresh petition of that claim, it's open to him. I cannot come in the way of him by filing an application before the time of suit.
Learned counsel for the petitioner and learned senior counsel for the respondents are physically present. Learned counsel for the petitioner submits that since the client filed by him in OS 597 of 2014 has been returned to him with a direction presented before the appropriate jurisdictional court having the pecuniary jurisdiction to try the matter. He is at liberty to make a fresh application when the client is represented before the appropriate court. As such, the present petition has become infructuous. He has to dispose of this petition, treating it as having become infructuous. However, he reserves his liberty to make an application afresh in accordance with the senior counsel for the respondent submits that since his client has been returned with a direction to present it at the appropriate court having pecuniary jurisdiction, the defendants cannot come in the way of the plaintiff's liberty to file the application in accordance with law. In the light of the above submissions, the petition stands disposed of as having become infructuous. However, filing of any application for the similar relief in the court where the client would be resubmitted, already submitted. However, filing of any application, similar application in the court which is said to be now seized of the matter is to be in accordance with law only. Yes. Yes, next.
Number 33, Prasanna VR. 33, Prasanna VR for the petitioner.
And take for the respondent. Upper station at the margin to be his native one. Kindly have it after 2 days. Inform the council for petitioner.
Then counsel for the petitioner, 11 junior, the which respondent?
Respondent number 1.
Respondent number 1, citing some medical reasons of his senior, prays for a short accommodation. This is the matter in the week after next. The interim order granted earlier is extended by 2 weeks from today.
34, Sandeep Nadavi.
Extension.
Number 35, Sabagati, Rajendra Kulkarni for the petitioner. Okay, another number for the respondent.
Respondent, your lordship.
or the respondent, Your Lordship.
Yes.
Yes, please. It is created for CH-10. Created by a petitioner file suit for refusal of
Remove the mask, please.
petitioner created petitioner. The petitioner model is created for file suit. And he filed
Petitioner was the plaintiff. Suit for recovery of money.
recovery of money.
Ah.
And earlier, the check for the defendant mortgaged his property situated 4 Mangla and obtained loan. And the loan was not paid. Thereafter, he pursued by me, then he issued check, and check bounced. Then PCR filed and CCR filed, then he was convicted. But before magistrate court, joint memo filed by both parties. But in joint memo, he agreed to pay the amount, but amount not paid. Then I filed suit before trial court for recovery of the amount.
Lordship.
But this is not the file WS, but liability is admitted. Subsequently, he filed IFP for amendment of WS. But under 6-17, that is amended. Then on the ground that the petitioner is not holding any control of insurance license. But that application was allowed, and thereafter, I have filed application for production of documents before the court order I-5-17 with seek of permission of the court. But that application is dismissed on the ground that whatever documents is now present produced before the court with I, not produced before the in the time of filing suit. But that is only one observation made by the trial court. But Article 7-43 provides not a daily movement would seek of you if not produced. The court can accept the documents Article 7-43. But not only physical evidence is led in to class 1. Issue frame the plaintiff led evidence and
To save the valuable time of the court, may I make this submission?
page 18. The application calculate 9.
With Lordship's permission, to save the time of the court, may I make a submission, Your Lordship?
Yes, please.
Lordship, at para number 3 of the writ petition, the petitioner has said that in the CC number 1387 of 2012, all this liability has been accepted. I want to bring to the kind notice of Your Lordship that after filing of this writ petition, that order has been quashed in the criminal appeal 1389 of 2016 on 9/8/2017, Your Lordship, and the same petitioner has assailed the setting aside order before this honorable court, Your Lordship. That I want to bring to the kind notice of Your Lordship. That's it, Your Lordship. A criminal case quash agide Swami. 13879 of 2012.
Criminal case quash adre. Civil suit for recovery may adrad influence in irala alve.
ಇಲ್ಲ ತಮ್ಮ ಗಮನಕ್ಕೆ ತಂದಿದ್ದಾರೆ ಪ್ಯಾರಾ ನಂಬರ್ 3 ನಲ್ಲಿ ಇತ್ತು ಸ್ವಾಮಿ, ಅದು ಯಾಕಂದ್ರೆ ಕನೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ತಮ್ಮ ಗಮನಕ್ಕೆ ತಂದಿದ್ದಾರೆ.
ನೋಡುವ ಅದನ್ನ. Where is your application seeking production of the document?
Page number 59, 58, 57 list of documents. So, 59, I have filed.
Before filing this application, had you already led your evidence and closed your side?
No. Only after completion of this matter, they have let evidence. Issue claimed and let evidence only. And that my way of my document to issue. Issue to P1 to P9. Thereafter, he filed application for amendment of WS. That is allowed under 12.6. 19/4/2017. Thereafter, in the amendment to this application, he raised the point that I have not got the control of license, control of insurance license. And thereafter, I filed application, this I filed for production of those documents, which is raised in the WS.
So my question to you is, you had already once led your evidence and marked the documents.
That is actually page number. Yeah, page 50.
Annexure F is additional evidence. I'm asking certain questions to make myself clear regarding the chronology of events or the facts. Initially, pleadings were completed, right? Issues were framed. After framing of issue, what happened?
And he filed application for amendment to WSO. The defendant.
After framing of issue, before you enter the witness box.
Before not, I have entered earlier in this box. But the synopsis case. Synopsis case 19/1/2001. 19/12/2014, not there is a criminal case, PCR and CC. So 27/10 people alone not the fire shoot for recovery. But 25/2/2016 different fire statement to. Then 97/2020 fire application for amendment W statement to. 26/2017 respond here further order for permitting him to raise additional evidence to. It will be in his statement to. But other that number 16/11/2017 3/1/2018 petitioner 25 IF5. But 19/1/2018 different respond here fire counter statement above application 63/2018 the application rejected. Before 2016, and the plaintiff get evidence before that.
On?
This is certificate of issue waived on 2nd January 2017. The appropriate date should not 4/2/2016, 4/2/2016. Let evidence and marked documents noted for cross examination. Defendant.
When you led your evidence?
4/2/2016.
ಮತ್ತೆ ಅದೇ ಪ್ರಶ್ನೆ ಅವಾಗಿಂದ ನಾನು ಕೇಳ್ತಿದ್ದೆ, ನೀವು ಅದೊಂದು ಬಿಟ್ಟು ಉಳಿದಿದ್ದು ಎಲ್ಲದೂ ಹೇಳಿದ್ರಿ. ನೀವು ಕ್ರೋನಾಲಜಿ ನಾನು ಕೇಳಿದ ಪ್ರಶ್ನೆ ಉತ್ತರವೇ ಇಲ್ಲ. When you led your evidence?
4/2/2016.
ಏನ್ ಎಕ್ಸಿಬಿಟ್ಸ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ರಿ?
Exhibit P1 to P10. P10. But exhibit P1 is registered simple ಮಾಡಿದ್ರೆ dated P1. Rectification dated 5/10/15.
ಒಂದು ನಿಮಿಷ. ಈಗ ನೀವು ಹೇಳ್ತಿರೋದ್ರ ಪ್ರಕಾರ the plaintiff led evidence on 4/2/2016, 4th February 2016. By that time, the issues were framed. In your synopsis, page 2 of the writ petition, you have shown on 25/2/2016, the defendant filed written statement. 21 days prior to defendant filing written statement, how can the court frame the issues and record your evidence? ನಾನು ನೀವು ಹೇಳ್ತೀರ ಡೇಟ್ ಹೇಳ್ತಿದ್ದೇನೆ ವಕೀಲ್ರೆ, ಮತ್ತೆ ಅದನ್ನು ಕರೆಕ್ಟ್ ಹೇಳ್ಬೇಕಲ್ವೇ? ಯಾವಾಗ ಅವ್ರದ್ದು ಮಿಸ್ಟೇಕ್ ಅಂತ ಬರ್ತದೆ, ಯಾವ ವಕೀಲರು ನನ್ನಿಂದ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಅಂತ ಹೇಳಲ್ಲ. ಅದು ಬಿಟ್ಟು ಬೇರೆದೇ ಟಾಪಿಕ್ ಹೋಗ್ತಾರೆ, ಬೇರೆದೇ ಉತ್ತರ ಕೊಡ್ತಾರೆ, ಕೋರ್ಟೇ ರಾಂಗ್ ಅಂತಾರೆ. ನೀವು ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ರೆ ಸ್ವಾಮಿ ನನ್ನಿಂದ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಹೇಳ್ಕೊಳ್ಳೋದ್ರಲ್ಲಿ ಸಂಕೋಚ ಯಾಕೆ ಬೇಕು? ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಅವಾಗಿಂದ ಕೇಳ್ತಾ ಇದ್ದೇನೆ ಕ್ರೋನಾಲಜಿ. ಅವ್ರು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾವಾಗ ಹಾಕಿದ್ರು, ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ಆಗಿದೆಯಾ, ಎಕ್ಸಿಬಿಟ್ ಮಾರ್ಕ್ ಆಗಿದೆಯಾ, ಯಾವಾಗ ಆಗಿದೆ? ನಿಮ್ಮ ಪ್ರಕಾರ 4/2/2016 ನಿಮ್ಮದು ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ. ಸೂಟ್ ಹಾಕಿದ್ದು ಡೇಟ್ ಯಾವ್ದು ಹೇಳಿದ್ರಿ? 27/10/2014, ರೈಟ್? ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಒರಿಜಿನಲ್ ಸೂಟ್ ವಾಸ್ ಫೈಲ್ಡ್ ಆನ್ ಯಾವ ಡೇಟ್ ಅಂತ ಹೇಳಿದ್ದೀರಿ? ಪೇಜ್ ನಂಬರ್ 2 ಆಫ್ ಯುವರ್ ರಿಟ್ ಪಿಟಿಷನ್. Who appears for respondent?
Lordship.
You are not supposed to switch off the video while your matter is being heard.
ನಾನು ತಮಗೆ ಡಿಸ್ಟರ್ಬ್ ಆಗಬಾರ್ದು ಅಂತ, ಬಟ್ ಐ ವಾಸ್ ಹಿಯರಿಂಗ್.
That is not a disturb. That is your duty to be present.
Yes.
Otherwise, it amounts to say while you are on your leg leaving the court hall without the permission of the court.
ಇಲ್ಲ, but sorry, your lordship. I thought I shall not disturb your lordship. You will call me so that much obliged.
That you cannot presume certain things on your own, Mr. Counsel.
Much sorry.
ಅವಾಗಿಂದ ನಾನು ಅವ್ರನ್ನ ಪ್ರಶ್ನೆ ಕೇಳ್ತಿದ್ದೇನೆ, ನೀವು ವಿಡಿಯೋ ಆಫ್ ಮಾಡ್ಕೊಂಡು ಕೂತಿದ್ದೀರಿ.
ನಾನು ನೋಟ್ಸ್ ಮಾಡ್ಕೋತೆ ಸ್ವಂತ, ತಾವು ಕೇಳಿದ್ ನಾನು ತಮಗೆ ಡಿಸ್ಟರ್ಬ್ ಆಗಬಾರ್ದು ಅಂತ ಅಷ್ಟೇ. ಓಕೆ.
ನಿಮ್ಮ ಪ್ರೆಸೆನ್ಸ್ ಕೋರ್ಟ್ಗೆ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಅಂದ್ರೆ ನೀವು ಸ್ವಿಚ್ ಆಫ್ ಮಾಡಿ ಹೊರಗಡೆ ಹೋಗ್ತೀರಿಯೇ?
ಇಲ್ಲ.
ಇಲ್ಲ ಅಲ್ವೇ? ಮತ್ತೆ why do you presume certain thing on your own?
Sorry, your lordship. Sorry.
Yes. When the alleged amendment was permitted,
My amendment, Your Lordship.
Yes,
My amendment was permitted on 19/4/2017, Your Lordship.
yes.
The
When did the plaintiff, whether the plaintiff has commenced or led his evidence? If so, on which date?
Your Lordship, plaintiff evidence examination is chief has been happened on 4/2/2016, Your Lordship. Examination, evidence by way of affidavit of plaintiff, it is on 4/2/2016. May I bring to your kind notice, Your Lordship, at page number 22, Your Lordship. The order, which is impugned here, Your Lordship, page number 22.
Yes,
The last at page number 22, at para number 9, Your Lordship.
yes.
The very reasoning assigned for the dismissal of the application of the plaintiff, the petitioner herein is that without pleading, he wants to mark the document.
No, I will come to that point later.
Yes,
Yes, on merit.
yes,
Just
sir.
I want to know myself to be clear on the chronological events. Whether after commencement of his evidence and closure of his evidence has he come up with the present application?
Yes, Your
At
Lord.
what stage of the suit the present application came to be filed?
Your Lordship,
I wanted to know that since his
may I make
chronology of events shown in the writ petition was
Your Lordship.
not clear. I was asking learned counsel from both sides.
Yes, Your Lordship.
By filing a mere application under Order 7, Rule 14(3) CPC, without there being any application or Order 18, Rule 17, how you are able to manage the show? According to you, you had already closed your side of evidence, right? On 4/2/2016.
And the, at 7 provide with leave of court. So it can be received by the court.
Subsequently,
This is not the at 7
sir, ಒಮ್ಮೆ Order 7, Rule 14 ಒಮ್ಮೆ ಓದಿ ನನ್ನ ಅನುಕೂಲಕ್ಕೆ.
Document which are to be produced before by the plaintiff will be presented. Are to the entire list to be added or annexed to the claim, but it is not produced or entered accordingly. They are not without the leave of the court. We received the evidence on his behalf after hearing of the suit. This is Article 15. With the leave of the court, can receive the application document. So, but the earlier is not raised in the not these files are not raised by defendant. After filing amendment, this part is raised. Therefore, the application for production back to the supporting nothing to order. Come with this with permission of the court. That is rejected and wrong that in the plaintiff you have produced before the plaintiff, not subsequently the obligation made by the court. That is not correct. You have to Supreme Court 13 Supreme Court before passing order there is Supreme Court order 13. But the 13 delivered must say that anything the answer.
What it says?
It says that Order 7/14 excel documents need to file. Single judge of the High Court on its usual side, trial judge dismissed the appeal application. Order upheld by the judgment of the High Court as matters in the stage of cross examination. Order of the judgment set aside, cross examination had not yet commenced. There is no reason for debarring the appealant from filing excel documents. Application under Order 7/14 allowed. Which is application of the
That is in the facts of that particular case, probably.
ಇದರಲ್ಲಿ ಅಪ್ಲೈನ್ ಡೈರೆಕ್ಟ್ ಇದರಲ್ಲಿ ಪ್ಯಾರಾ 1 ನಾಟ್ ಪ್ಯಾರಾ ಇದೆ ಇದನ್ನು
Sorry.
ಪ್ಯಾರಾ 1 the new granted appearance are direct judgment.
What is the principle laid down in that order? ಈ ಕೇಸಲ್ಲಿ ಏನ್ ಹೇಳಿದೆ ಅಂತ ಹೇಳಿದೆ ಹೊರತು ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಏನಾದ್ರೂ ಪ್ರೆಸಿಡೆಂಟ್ ಇದೆಯೇ? ವಕೀಲರೇ, ತಾವು ಲಾ ಆಫ್ ಪ್ರೆಸಿಡೆಂಟ್ ರೇಷಿಯೋ ಡಿಸಿಡೆಂಡಿ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಬಲ್ರಿ ತಾನೆ? ವೆದರ್ ದಿಸ್ ಅಬ್ಸರ್ವೇಷನ್ ಬೈಂಡ್ಸ್ ದಿಸ್ ಕೋರ್ಟ್, whether this judgment acts as a precedent.
But even similar set of facts, the application is rejected and allowed with petition and set aside the order.
ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಮಾಡಬಾರ್ದಂತಿಲ್ಲ ವಕೀಲ್ರೆ. ನೀವು ಅದನ್ನ ಯಾಕೆ ಅಲೋ ಮಾಡಿರೋದು ನೀವು 10 ತಂದ್ರೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿರೋದು 20 ಜಜ್ಮೆಂಟ್ಗಳು ಸಿಗ್ತಾವೆ. ಅಲೋ ಮಾಡಬಹುದು, ಅಲೋ ಮಾಡಬಾರ್ದು ಅನ್ನೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ ಇಲ್ಲಿ. ಅಲೋ ಮಾಡ್ಲಿಕ್ಕೆ ಒಂದು ಅವಕಾಶ ಕಾನೂನೇ ಕೊಟ್ಟಿದೆ. ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ಅಲೋ ಮಾಡತಕ್ಕದ್ದು ಆ ಪ್ರಿನ್ಸಿಪಲ್ ಏನಾದ್ರು ಲೇ ಡೌನ್ ಮಾಡಿದ್ರೆ ಅದು ನಿಮಗೆ ಬೈಂಡಿಂಗ್ ಪ್ರೆಸಿಡೆಂಟ್ ಆಗುತ್ತೆ.
ಅವ ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಯೂಸ್ ಮಾಡಿಲ್ಲ.
ಹೌದು,
ಹಾಕಿದ್ದೀನಿ.
ಹೌದು,
ಅದಕ್ಕೆ ಇದು ದವ ಹಾಕುವ ಯೂಸ್ ಮಾಡಿಲ್ಲ, ಸಬ್ಸಿಕ್ವೆಂಟ್ ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ರಿಜೆಕ್ಟೆಡ್ ಅಪ್ಲಿಕೇಶನ್ ಅವು ಇದ್ರ ಪ್ರಕಾರ ತಪ್ಪು ಅಂತ ನಾನು ವಾದ. ಸಿಕ್ಸ್ ಪರ್ಮಿಷನ್ ಗಿವ್ ಆಫ್ ದಿ ಕೋರ್ಟ್ ಮಾಡಬಹುದು. ಅದಕ್ಕೆ ಇದು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿದರೆ ನಾನು
ಇದು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿದ್ದಲ್ಲ ವಕೀಲ್ರೆ. ಹೌದು, ಅದು ಡಿಸ್ಕ್ರಿಷನ್ ಆಫ್ ದಿ ಕೋರ್ಟ್. ಅದು ಡಿಸ್ಕ್ರಿಷನ್ ಆಫ್ ದಿ ಕೋರ್ಟ್. ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಎಕ್ಸರ್ಸೈಸ್ ದ ಡಿಸ್ಕ್ರಿಷನ್ ಪ್ರಾಪರ್ಲಿ.
ಇದರಲ್ಲಿ ಅಂದ್ರೆ ನಾವು ಕಂಪ್ಲೀಟ್ ಎವಿಡೆನ್ಸ್ ಆಗಿಲ್ಲ, ಬಟ್ ಅಡಸಿಗೂ ನಾನು ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ರೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಅವ್ರ ಕ್ಲಾಸ್ನ ಕನ್ವಿನ್ಸ್ ಆಗಿಲ್ಲ. ಅದಕ್ಕೆ ಬಾರ್ ಇನ್ ಎಂಟ್ರಿ ಬಾರ್ ಇನ್ ಎಂಟ್ರಿ ಒಪ್ಪಿದ್ರು ಈ ಹೈಕೋರ್ಟ್ ಕಂಪ್ಲೀಟ್ ಎರರ್ ರಿಜೆಕ್ಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್. ಅದಕ್ಕೆ ಸ್ಯಾಟಿಸ್ಫೈಡ್ ಅಂಡ್ ಡೈರೆಕ್ಟ್ ಕನ್ಸಿಡರ್ ಕೋರ್ಟ್ ಟು ಕನ್ಸಿಡರ್ ಇನ್ ಆಫೀಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ರೆಫರ್ ಮಾಡಿದ್ರೆ ಈ ಮಾಡ್ಸೋ ಹೋಗಿ ಕಮಿಟಿ.
Yes, Mr. Counsel for respondent.
Lordship.
Yes, what is your argument?
My argument is that, Your Lordship, the evidence of the plaintiff has been, by the examination in chief, it has been concluded on 4/2/2016, Your Lordship. Later, I filed a written statement. I bought certain things. I set up a defense in the written statement, Your Lordship. For that purpose, they want to place a additional evidence along with the document. The impugned order has been,
When did you file your written statement?
written statement is on 25/2/2016, Your Lordship.
That means after the plaintiff closing his evidence, you filed the written statement
Yes, Your Lordship. Yes, Your
after the closure of his evidence.
Yes, Your Lordship.
Issues were framed subsequently.
Yes, Your Lordship.
After framing of the issues, whether the plaintiff was given an opportunity to lead his further evidence, if any.
ಅಲ್ಲ ಇದು ಪ್ಲೈಂಟಿಫ್ ಇದು ನನ್ನ ಅಡಿಷನಲ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ 19(4) ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ. ಅದು ಕೂಡ ಪ್ಲೈಂಟಿಫ್.
ನನ್ನ ಪ್ರಶ್ನೆ ನೀವು ಕೂಡ ಸರಿ ಉತ್ತರ ಕೊಡ್ತಾ ಇಲ್ಲ.
ಪ್ಲೈಂಟಿಫ್ ಎವಿಡೆನ್ಸ್ ಆದ್ಮೇಲೆ ನಾನು ಮಾಡಿರೋದು. ಪ್ಲೈಂಟಿಫ್ ಎವಿಡೆನ್ಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇನ್ ಚೀಫ್ ಆದ್ಮೇಲೆ, ದಟ್ ವಾಸ್ ಆನ್ 4/2/2016. ಲೇಟರ್ I got the amendment for the written statement on 19/4/2007.
ನನ್ನ ಪ್ರಶ್ನೆ, ನೀವು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಬೇಕಾದ್ರೆ ಪ್ಲೇಂಟಿಫ್ ನ ಎವಿಡೆನ್ಸ್ ಆಲ್ರೆಡಿ ಮುಗಿದಿತ್ತು ಅಥವಾ
ಮುಗಿದಿತ್ತು.
ನಂತರ ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಮಾಡಿತ್ತಾ ಕೆಳಗಡೆ ಕೋರ್ಟು?
ಇಶ್ಯೂಸ್ ಕೂಡ ಫ್ರೇಮ್ ಆಗಿತ್ತು.
ಫ್ರೇಮ್ ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಮಾಡಿದ ನಂತರ ಪ್ಲೇಂಟಿಫ್ ವಿಟ್ನೆಸ್ ಬಾಕ್ಸ್ ಎಂಟರ್ ಆದ್ರ?
ಇಶ್ಯೂಸ್ 2/1/2017 ನಲ್ಲಿ ಆಗಿತ್ತು. ಆಗಿತ್ತು.
ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಆದ್ರ ಮೇಲೆ ನೀವು ಎವಿಡೆನ್ಸ್ ಏನಾದ್ರು ಮಾಡ್ಲಿಲ್ಲ? ನೀವು ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಆದ್ರ ಮೇಲೆ ಅವ್ರು ಅಡಿಷನಲ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದ ಅಥವಾ ಅಡಿಷನಲ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಗಿದ್ದ ಅಥವಾ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆದ್ರ ಮೇಲೆ ಇಶ್ಯೂಸ್ ಆಯ್ತಾ?
ಹಾಕಿದ್ದಾರೆ ಅವ್ರು ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಇಲ್ಲಿ ಆರ್ಸಿದಲ್ಲಿ ಡಿಪೆಂಡೆಂಟ್ ಅಂಡ್ ಇಸ್ ಕೌನ್ಸಿಲ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಾಟ್ ಫೈಲ್ಡ್ ಹೆನ್ಸ್ ಕ್ಲಾಸ್ ಎಕ್ಸಾಮಿನ್ ಆಫ್ ಟೇಕನ್ ಬಿಲ್ ಅಂತ ಆರ್ಸಿಟ್ ತೋರುತ್ತದೆ.
ಯಾವತ್ತಿನದದು?
4/2/2016.
WS ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತಿದೆ.
ಡಿಪೆಂಡೆಂಟ್ ಎವಿಡೆನ್ಸ್ ಆಯ್ತು, ಡಾಕ್ಯುಮೆಂಟ್ ಮಾರ್ಕ್ ಆಯ್ತು. ಕ್ಲಾಸಿಕ್ ಟೈಪ್ ಹೋಗಬೇಕಾದ್ರೆ dependent and is counsel absent to written statement not filed, hence cross examination is taken as nil. ಆಮೇಲೆ ಈಗ ನಾನು ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಅವ್ರದ್ದು ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿದ್ರು.
ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿದ್ರ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ರ?
25/2/16ಕ್ಕೆ WS ಹಾಕಿ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿದ್ರು. WS ಅಮೆಂಡ್ಮೆಂಟ್ ಅದು 16/2/17ಕ್ಕೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಆಯ್ತು. ಆದ್ಮೇಲೆ ನಾನು ಈ ಹಾಕಿದ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ವಾಟ್ ಇಸ್ ರೇಸ್ಡ್ ಇನ್ ದಿ WS ಆ ರೇಂಜಿಗೆ ಫೈಟಿಂಗ್ ನಾನು ಸಪೋರ್ಟ್ ಮಾಡಿ ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕ್ತಾ I5. Earlier WS admits categorically admits liability and subsequently amendment there is no license of the plaintiff there is application amendment ಹಾಕಿದ್ರು. ಅದು ಅಲಾವಾಯ್ತು. ಆದ್ಮೇಲೆ ನಾನು ಈ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಪೊಲೀಸ್ ಮಾಡಿ ಅದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೆ I5.
ನಕ್ಷಲಲ್ಲಿ ಹೇಳ್ಬೋದು ಬೇಡ, ಡೇಟ್ಸ್ ಏನಾದ್ರು ಹೇಳ್ಬೋದು.
Application under 7/14 CPC filed by him as a plaintiff cum applicant in OS number 814/7/2014 in the court of so and so. Suit for recovery of money.
ನಾನೊಂದು 10 ಸೆಕೆಂಡ್ ಒಂದು ಹೇಳಲ್ಲ ಸ್ವಾಮಿ. 10 from my part, Your Lordship.
Trial court on 16/3/2018. Agreed by the same, the plaintiff in the original suit has filed this petition. The undisputed fact is before the defendant filed his written statement, the plaintiff in the trial court had already led his evidence on 4/2/2016 and had already marked the documents from Exhibit P1 to P10. According to learned counsel from both sides, the written statement came to be filed in the trial court only on 25/2/2016. Subsequently, the defendant's application seeking amendment of his written statement also came to be allowed with the trial court on 19/4/2017. It is thereafter the present petitioner as a plaintiff in the trial court filed IA number 5 under Order 7 Rule 14/3 CPC on 3/1/2018. Which application is at Annexure 8. The contention of the applicant in the trial court in his IA 5 was that since in the amendment to the written statement, the defendant had raised certain issues alleging that certain aspects alleging that the plaintiff did not possess a valid license for money lending and such other things, it was constrained for the plaintiff to file the IA5 under consideration, seeking permission to produce additional documents. The defendant objected to the said document, said application, stating that there is no corresponding pleading in the plaint. Upholding the said contention, the trial court rejected the application filed by the plaintiff. A perusal of Order 7 Rule 14/3 of CPC go to show that whenever the parties to the litigation fails to produce the document along with their pleading, the court at a later stage may, in suitable cases, permit them to produce the document. Thus, there is no prohibition from producing the document at a later stage during pendency of the suit. In the instant case, admittedly, PW1 has not yet been cross-examined. The only reasoning as well the contention of the defendant that there is no corresponding pleading in the plaint of the plaintiff about a document which he is intending to produce now cannot be a reason for denying the production of the document. It is because if no such corresponding pleading is there, the defendant would be always at liberty to contradict with those suggestions to plaintiff witnesses in their cross-examination and also bring to the notice of the court at the time of appreciation of the evidence, both oral and documentary, about the absence of the pleading, and about the evidentiary value of the documents and oral evidence in the absence of the pleading. As such, merely protruding the reason that there is no corresponding pleading, as such the plaintiff cannot produce the document even with the leave of the court under Order 7 Rule 14/3 CPC is not a convincing reason. Accordingly, therefore, the impugned order does not sustaining the eye of law and deserves to be set aside. Accordingly, the order dated 16/3/2018, passed by so and so in OS number 8147/2014 and IA number 5 is quashed. We said IA number 5 filed under Order 7 Rule 14/3 CPC stands allowed, and the applicant of the plaintiff is permitted to produce the additional documents shown by him. The list of additional documents dated 3/1/2018, bracket annexure G. However, the acceptability of those documents in the evidence and proof of those documents are left open to be considered by the trial court at the appropriate stage, provided the necessity for the same arises. Yes.
Number 36, V.P. Shivkumar. 36.
An appearance the matter not
Number 37.
wish the matter in the book of
Petrol. 38, Nayak N.R.
by getting the matter listed. Getting a memo for posting, the learned counsel for the petitioner has remained absent. Learned counsel for respondent number 1 and 2 alone present, hence the matter could not be proceeded today. Just the matter. To be called.
39, Nagar Reddy.
Also, I appear for the respondent in this matter, my lords.
Sample to the respondent.
My lords, I appear for the respondent in this matter, my lords. The relief in this petition is for a mandamus to consider the representation with regard to 5 lakh of rupees of compensation not being paid. Lords, I submitted on the last date also. Subsequent to filing of this writ petition, they have collected this amount of 5 lakhs. Therefore, the reliefs have become infructuous, my lords.
The petition has become infructuous.
Yes, my lords, because after this petition, the amount of 5 lakhs has been paid to them.
Given after year 2016.
They have deposited the amount now. Demand draft they have given. They have accepted the demand draft. Except a bare demand draft, they have not given anything to you in writing. Demand draft are given to you in this proceeding or outside or in a different proceeding. Order sheet al bandilla adu.
Statement of objection, they say, you know, the amount has been already given. Particular subject note, it has not come to my account. There are some notes, there are state notes, it is in some cooperative society in Kolar. Court direct part to the OVL, but they have taken me to Masangudi.
How much of the amount was given to you? 5 lakh. Then how come this writ petition survives now? Idu money recovery suit ಏನ್ರಿ ಅಲ್ಲ ಅಲ್ವೇ? ನಿಮ್ಮ representation consider ಮಾಡಬೇಕು ಅಂತ ಕೇಳಿದ್ದೀರಿ. ನಿಮ್ಮ representation ಅಲ್ಲಿ 4,95,000 rupees ಕೇಳಿದ್ದೀರಿ. ಅವರು ಅದಕ್ಕಿಂತಲೂ 5,000 ರೂಪಾಯಿ ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ನನ್ನ ಪ್ರಶ್ನೆ ಇದು ಮನಿ ರಿಕವರಿ ಸೂಟು ಅಲ್ಲ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಅಲ್ಲ, ನೀವು ಡಿಗ್ರಿ ಹೋಲ್ಡರು ಅಲ್ಲ. ರಿಟ್ ಆಫ್ ಮ್ಯಾಂಡಮಸ್ ಹಾಕಿದಿರಿ ಟು ಕನ್ಸಿಡರ್ ಯುವರ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್. ಯುವರ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಹ್ಯಾಸ್ ಬಿನ್ ಕನ್ಸಿಡರ್ಡ್ ಇನ್ ಒನ್ ವೇ ಆರ್ ದಿ ಅದರ್. ಅಪಾರ್ಟ್ ಫ್ರಮ್ ಮಿಯರ್ಲಿ ಗಿವಿಂಗ್ ಯು ಎನಿ ರಿಪ್ಲೈ ಇನ್ ರೈಟಿಂಗ್, they have even paid you the money also. That means your representation has been considered and to some extent it has already been acted upon by them. You have accepted it. If you are still not satisfied with the same, you get a separate cause of action to proceed in accordance with law, provided the law permits you. But you cannot maintain this writ petition and ask them to pay the interest. ಹೌದ್ರಿ, ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಬದಲಾಗಿ ನಿಮಗೆ ದುಡ್ಡೇ ಕೊಟ್ಟಿದ್ದಾರೆ. ನೀವು ಅವಾಗ ದುಡ್ಡು ತಗೊಳ್ಲಿಕ್ಕೆ ಮುಂಚೆ ಹೇಳ್ಬೇಕಿತ್ತು, ನನ್ಗೆ ಬರ್ದು ಕೊಡ್ರಿ, ಬಡ್ಡಿ ನೀವು ಕೊಡೋದಿದೆ ಅದನ್ನ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಬರ್ದು ಕೊಡ್ರಿ, ಆಮೇಲೆ ತಗೊಳ್ತೇನೆ, ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಕೊಡ್ರಿ, ನಾನು ಕೋರ್ಟಲ್ಲಿ ಹೇಳ್ತೀನಿ, ಕೋರ್ಟಲ್ಲಿ ಇಸ್ಕೊಳ್ತೀನಿ. ನಾನು ಏನು ಮಾಡಲಿಲ್ಲ, ಔಟ್ಸೈಡ್ ದ ಕೋರ್ಟ್ ನಿಮ್ ಪಡೆ ನೀವು ಇಸ್ಕೊಂಡಿದ್ದೀರಿ. ನಿಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲಿ 4 ಲಕ್ಷ ಚಿಲ್ಲರೆ ಕೇಳಿದಿರಿ, ಅವ್ರು 5 ಲಕ್ಷ ನಿಮ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೇಳಿದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದಾರೆ. Statement of objection.
On 5/4/2015, that disputed. Amount has been given. Amount which they have stated to be given on 5/4/2016 has not come to my account.
ಅಲ್ಲ ರೀ, ಅದನ್ನ ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ನಾವು ಡೀಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗತ್ತೆಯೇ? ಈಗ ನನ್ನ ಎದುರು ಇರೋದು ನಿಮ್ಮದ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೋ ಇಲ್ವೋ? ನಿಮ್ಮ ಪ್ರಕಾರ, ಅವ್ರ ಪ್ರಕಾರ ಮಾಡಿದ್ದೇವೆ. ಅನಕ್ಷರಕ್ಕೆ ನಿಮ್ಮ ಪ್ರಕಾರನು ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ ಅಲ್ಲ, ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾರೆ, ಆದ್ರೆ ಅದು ಸಾಲದು. ರಿಟ್ ಅಲ್ಲಿ ಸರ್ವೈವ್ ಆಗ್ತದೆ. Present petitioner has sought for issuance of a writ of Mandamus. Present petitioner has sought for an issuance of writ of Mandamus, seeking a direction to the respondent to consider his representation dated 3/7/2021 bracket annexure K, wherein he has sought to pay the compensation amount with interest from the date of alleged utilization till realization. The contention of the petitioner was that his agricultural land was used by the respondent company for drawing electricity line. However, the compensation for which he was entitled to was not paid to him. It is in that regard, as per Annexure D, Annexure K, he had made a representation dated 3/7/2021 to the respondent, requesting them to pay the alleged remaining compensation amount of a sum of rupees 4,95,000 with accrued interest. The respondents entered appearance and filed their statement of objection, contending that they have already paid the substantial amount, the details of which also have been given by them in their statement of objection. However, learned counsel from both sides today make a submission that during the pendency of this writ petition, and after the respondents filing their statement of objection, the petitioner has been paid with a total sum of rupees 5 lakh in the form of a demand draft by the respondent. Though the learned counsel for the petitioner contend that the alleged interest has not been paid to him, however, he concedes that his representation at Annexure K accordingly stands considered in one way or the other. The learned counsel for the respondent submits that in view of the consideration of the representation of the petitioner at Annexure K, the prayer made in the writ petition for issuance of writ of mandamus does not survive, as such the writ petition has become infectious. In the light of the above, reserving liberty to the petitioner to approach the competent forum for his alleged claim towards the interest, if any, the writ petition stands disposed of as having become infectious. Sir. Yes, please. You have been coming every day. Yes. ಆಗ್ತದೆ ಕೆಲವೊಮ್ಮೆ ವಿಷಯಗಳು ಸಣ್ಣದಿರ್ತದೆ, ಉದ್ದ ಜಾಸ್ತಿ ಹೋಗ್ತದೆ. ಅದು ಒಂದೊಂದು ಪ್ರಾಪರ್ ಫೀಡ್ಬ್ಯಾಕ್ ಬರದೆ ಹೋದ್ರೆ ಅಥವಾ ನನ್ನ ತಾಳ್ಮೆ ಕಳ್ಕೊಂಡ್ರೆ ಎರಡರಲ್ಲಿ. ಎಸ್ ಹೇಳಿ, ಯಾವಾಗ ಮಾಡ್ತೀರಿ? ಹೆವಿ ಇದೆ ಈ ವಾರ ಬಿಟ್ಟು. ಸೋಮವಾರ ಎಷ್ಟಿದೆ? ಹೌದು, ಯು ಹ್ಯಾವ್ ಬಿನ್ ಕನ್ಸಿಡರ್ಡ್. ಪಾಪ ದಿವಸ ರೀಚ್ ಆಗದೆ ಆದ್ರೆ ನೀವು ಮತ್ತೆ ಈ ಕೌನ್ಸಿಲ್ ಇಬ್ರು ಪಾಪ ವೆಯ್ಟ್ ಮಾಡಿ ಹೋಗ್ತಿದ್ದೀರಿ 2 ದಿವಸದಿಂದ. ಸೋಮವಾರ ಹಾಕ್ಸಿ, ಸೋಮವಾರ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಹಾಕಿರ್ತೀನಿ ನೋಡಿ. Learned counsel from both sides present. Since the court time is over, the matter could not be proceeded today. List this matter on 11/4/2022 on the top of the list. Party? ನಾಳೆ ಬೇಡ ರೀ, ಈ ವಾರ ಬೇಡ. ತಗೊಳ್ಬಹುದು, ವಾಟರ್ಡ್ ಆಗಿದೆ ಅದು. ಅದರ್ ಸೈಡ್ ಇದ್ದಾರಾ? ಗೌರ್ಮೆಂಟ್ ಇದ್ದಾರೆ. ಗೌರ್ಮೆಂಟ್ ಮಾತ್ರ ನಿಮಗೆ? ಹೌದು, ಓನ್ಲಿ ಗೌರ್ಮೆಂಟ್. ಹಾಕೊಳ್ಳಿ. learned counsel from both sides present. Since the court time is over, the matter could not be reached. ನಾಳೆ ಇರ್ತಾರೇನ್ರಿ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡೋರು? ನೀವೇನಾ ನಿಮ್ಮ ಕೌಂಟರ್ ಪಾರ್ಟ? ಕರ್ಕೊಂಬನ್ನಿ. ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್. ನಾಳೆ ಡೇಟ್ ಹಾಕಿ. ಎಸ್. Yes. At the request of the learned counsel for the petition, this matter in the week after next as prayed. Yes. I think.
43, my lord.
43 week after next I3.
Much obliged, my lord.